समस्त आम चैनल क्रिएटिव आइडिया स्वागत। तेबे 16 तारिख गोटे ऑर्डर निश्चित भाव में आपण को माने संतोषजनक उत्तर प्रदान करिवो। आमे जानिजे किछि जज कर किछि जजमेंट हमको भल लागेनी, आम फॉर रे जाएनी, आउ किछि जजमेंट निश्चित भाव में समाज रो मंगल पय हे थाए। आ ए जो जजमेंट आसे 16 तारिख मु तार कंप्लीट आपण को विजुअलाइजेशन देखेबी। तो एथिरे गोटे जिंस भल लागिला जे जदि कौनसी ऑफिसर भूल करूछंती देन पब्लिक कहीं सफर हेबे, पब्लिक को पैसा कहीं खर्च हम। अर्थात जितेबाला कौनसी ऑफिसर भूल करूछंती दैट इज नियुक्ति प्रक्रिया रे हो बा कौनसी सर्विस कंडीशन रूल रे हो, कौनसी क्षेत्र में भूल करूछंती ताहले अपोजिट पार्टी जदि आमे जाउछे कोर्ट को, आमे पैसा खर्च करूछे बट ऑफिसर पे गवर्नमेंट पैसा दउची आ गवर्नमेंट ता घर आनी दउ नांदी। ठीक अच्छे, तो गवर्नमेंट आम पैसा नौकरी, आम टैक्स पैसा नौकरी, अर्थात पब्लिक मनी खर्च हो। ठीक अच्छे, तो से क्षेत्र में ये कोर्ट डायरेक्शन देइछंती गोटे रिहाबिलिटेशन केस रे जदि डिले होउची, जदि कोर्ट ऑर्डर कंसर्न ऑफिसर मानु नाहांती, लिमिट ऑफ 3 months टाइम देइछंती रिहाबिलिटेशन केस रे, ताहाले पिटिशनर को पर डे 500 रुपीज लेखाएं देबाक पड़िबो फ्रॉम हिज पॉकेट एंड नॉट फ्रॉम द पब्लिक मनी। सरकार पैसा देवेनी, सरकार तहबिल पैसा जीवनी तांको पॉकेट रू, दैट मीन्स से कंसर्न ऑफिसर दरमारू पर डे हिसाब रे 500 रुपीज लेखा काट करा जिवो एंड से पैसा पिटिशनर को दिया जिवो। निश्चित भाव में आपण ए कंप्लीट जजमेंट देखिए एंड मते भल लागला ए जजमेंट कहीं रिक्रुटमेंट बहुत सारा माने एरोगेंसी चलती ओडिशा रे, मनमुखी आपणकर रिक्रुटमेंट प्रोसेस एंड सर्विस कंडीशन, एम्प्लॉय मानू प्रमोशन न देबा, दरमा बंद कर देबा, हरास करबा, बहुत दिन चलती। तो फॉर दैट रीजन द ऑफिसर हु इज कल्प्रिट जे आपणकर ब्राइब नौची एनी केस रे आपणकर, तो से ही सफर हुआ दरकार आउ तांकु ही फाइन रहा दरकार। आउ से केस पे गवर्नमेंट एडवोकेट को जहाँ फीस रही, गवर्नमेंट एडवोकेट जहाँ खर्च रही, कोर्ट जहाँ खर्च रही कंसर्न ऑफिसर द्वारा आवश्यकता रही। तो मुझे कंप्लीट जजमेंट देखी दूसरी। निश्चित भाव में आपन को एभली किसी आपणकर एक्सपेक्टेशन रहिबो जज मानकठू जे जदि ऑफिसर भूल करूचंती से ही पनिश्ड होंतु।
It is the petitioner is challenging the rejection order of his application, rehabilitation application, my lord.
On what ground it is rejected?
The challenge with the ground the applicant has applied for appointment on 24/2013, that is after completion of more than 2 years of date of deceased. It has violated the provision of after 2 years, my lord. Page 30, my lord.
1 second. So your compassionate appointment application is rejected.
My lord.
When death of employee happened?
Date of employee 22/12/2010, my lord. 22/12/2010, my lord.
22/12/2010.
My lord.
Yes.
Page 31, my lord.
Page 31. That is the death certificate.
No, my lord. The petitioner has approached this principal.
I want that is rejected, na?
Earlier, my lord, petitioner applied for 2012. What happened, my lord? Legal hair certificate is necessary. My lord, one Rajana Naik, he was file a claim, my lord, that she is wife of deceased, my lord. She has filed an appeal, my lord. The appeal was rejected on 5/7/2014, my lord.
Now, where is the impugned order? Go to take me to the impugned order, brother.
My lord, impugned order, my lord, page 30, my lord. And page 30.
30?
30, my lord.
Go to 30.
My lord. Relevant portion, Rajana Naik, though had relation with the Dhobi Naik, she is not the legal heir married wife of Dhobi Naik, hence she is not entitled to get the benefits as a legal heir of late Dhobi Naik, as the first and second wife are predeceased Dhobi Naik, the only legal heir who have living as follows, my lord. Thereafter, legal heir certificate issue, my lord.
No, this is Sub-collector's order.
Lordship, improved order page 42, my lord.
42, my lord.
42. Page 11, annexure 11, my lord.
This ground are stated in the application, my lord. Without legal hair, she cannot apply in the court, my lord.
In this case, we have already received the instruction to file.
After Jita Loha judgment, my lord.
That is more than 2 years after death of the employee.
My lord,
What is
without
the period?
my lord, after judgment of the Jita Loha judgment, my lord, the director of education Odisha circular the all district education officer and this is the notification saying that last month it was emphasized the application shall not reject to technical grounds, my lord.
Where is the technical ground?
But,
If a suit is filed after limitation and if it is dismissed, can it be said that suit is dismissed on technical ground?
my lord, annexure, my
Entitled to best point.
before my lord 2 years, my lord, annexure page 13, my lord, annexure 3, the petitioner has applied for to the principal, my lord.
To the principal.
My lord, this is a receipt, my lord, page 31, my lord.
Who is the appointing authority?
Page 31, 10/9/2011, my lord.
No, who is the appointing authority? Well, the application given to the appointing authority is the correct date for reckoning,
My lord.
not to XYZ.
My,
It should be routed through the principal.
he is stating and the legal hair certificate, my lord. Without legal hair, she cannot apply, my lord.
When
Legal hair is necessary, my lord.
when she applied for legal aid certificate.
Not, my lord. My lord, legal hair is the issue, my lord.
No, when he applied, that's very important.
Page 25, my lord. Page 25. She has applied prior to that, my lord. 27/12/2012, my lord. Legal hair certificate issue.
You are not answering.
She has applied 2011, my lord. After date of
You applied in 2000 after 2 years, more than 2 years. Death happened on 22/12/2010.
my lord.
You applied on which date, brother?
Applied in 2011, my lord.
Huh?
2011, I applied 2011.
Show that. It cannot be 2011 because your legal aid certificate itself is 27/12/2012.
Because of my lord, because of one Rajna Naik.
Where is your application that you applied in time? These are policy matters. Where how can once we relax that. The rest of the people will come saying that you are relaxed there and you also relax now. It will become 2 years, 3 years, 5 years, and some other person may say after 10 years also. Where is your application? When did you apply for cash certificate? Where is your application for a compassionate appointment?
That has been produced.
Who produced that copy?
No.
Call on 1811 petitioner to produce the copy of application for compassionate appointment and also the date on which he had applied for legal heirship certificate. But feeling which petition may be dismissed on that ground itself. Okay.
My lord, email number, legal certificate number 153/2011. That's why he has applied, my lord. 2011. The certificate miscase number 1558/2011. Page 25. 2011 application, my lord. Miscellaneous certificate case number 1558/2011, my lord.
You had applied for that.
For that, my lord.
But you applied for appointment on which day? Rehabilitation on which day?
Without legal.
No, without legal aid you could not have applied is one argument.
I have all.
Yes, brother, there are some issues now. Well, unless father dies or husband dies, the children or the widow cannot apply for legal aid certificate. Okay. After death, if they apply, they will take 3 years for issuance of the legal aid certificate. By that time, the period for applying for a rehabilitation appointment is over. What should happen to such people? Because your application should be accompanied by a legal aid certificate. Without that, they cannot apply at all. But they will not be able to get the legal aid certificate within 2 years at all. Then virtually you can defeat their right to rehabilitation. Now, as has happened in this case, the time was spent in obtaining the legal aid certificate. Matter went in appeal, there was some dispute, time was spent. Your format says the application should be accompanied by legal aid certificate. Then every application can be defeated and compassionate appointment can be denied to everybody by just telephoning your officer who issues legal aid certificate. Don't decide it for another 6 months. Everything will be over. A larger issue is involved in this case. Where is your objection? What objection you have taken up?
They have received the instruction to file the affidavit.
How much time is being wasted without deciding matters at all? You produce that application and the date on which you had applied for legal aidship certificate. State you will do that. Petitioner to produce, not dismissal, etc.
Has to produce the letters. State has produced.
Any statement of objection you have to do. See, in computing the period of, just I am thinking this way. In computing the period of 2 years, the period spent in obtaining the legal aid certificate should be discounted. Like section 14 of the Limitation Act, where you have taken time to obtain the certified copy of the order, then limitation begins from the date you obtain.
In that case, when he has obtained the death certificate and when he applied the legal aid certificate, that should be all.
For obtaining death certificate, time is required. For obtaining legal aid certificate, time is required. Matter will be taken in appeal. Appeal will take 5 years, like judges like me. Then by that time, the period for applying for compassionate appointment will be expiring. Where they should go. Therefore, in this matter, you help me. Both of you help me, so that I will lay down. I will say the time taken for death certificate, that should be the time taken for the legal aid certificate should be discounted while computing the period of limitation for applying the rehabilitation certificate. That will do justice to everybody.
That's why circular is made.
Circular says what? On technical ground, you should not. But question is, limitation is not technical ground. Technical ground means, suppose they have to put the color photograph, but they have put black and white photograph. The photograph should be 5 mm into 6 mm.
In that matter, there are mentioned applicant are at liberty to submit a new application to additional requirement documents within this was be also have to glance
the limitation.
No, that will not help.
All round is after judgment of the Loha Jita Loha case, my lord. This circular has been placed to all district education officer, my lord.
No, whether the period taken for this one is discounted, that is not mentioned.
All pending application in relation to the government employees prior to the applicants are liberty to submit a new application to additional requirement documents within 12 weeks. The judicial authority.
Well, which is the period? What is the period for applying rehabilitation appointment?
That is 1 year. 2 years.
1 year from the date of death.
Yes.
Some difficulties arise actually. Where is the application format? Which are those rules? Mr. Sven, just help in this matter.
CSRA rules 1990.
Now there are 25
That amendment is there. 2020 rules came into force and thereafter amendment was incorporated in 2022.
Just give the book. Just see whether there is a format. And format
Yes,
requires
there is a
airship
format.
certificate.
There is a format.
There is a format.
There is a format.
Whether it requires production of airship certificate.
My lord,
Airship certificate, legal airship certificate.
Yes.
Just looking.
that format is there.
Otherwise,
It is-
great injustice will be caused.
RA rules. 1990. 1990.
There is no such problem.
The format is there. Format is there. The legal air nahi, format is there. The format is there.
Otherwise, a very great injustice will happen to the applicants.
Yes.
Under section 14 of the Limitation Act, time spent for doing certain things
Yes.
is excluded.
Yes. The legal air, format is there.
Format is there. No, whether that format requires a legal air certificate.
It's a composite. It's a composite form
Huh.
in which a candidate has to apply.
Correct.
There are certain
that
colors.
form only when the candidate can apply is after he gets that legal air
That
certificate.
is
Legal
what
air
I'm
and death
telling you
certificate.
now.
So
Legal
the-
air and death certificate.
We can't apply for legal air certificate
Exactly.
in advance, saying
Exactly.
that my father is going to die on such and such day. Give me legal air certificate.
Cannot.
It cannot be.
So that format below it content the chapter 4, chapter IV, which is relating to distress certificate to be granted by the collector of the
By the
district.
collector, that
That
in
is
the
what
below
self
portion.
content format.
That is a format. Rehabilitation according.
That is
I'll call this matter afternoon.
That is
Preparation,
annexure.
I will write. Any court consider this aspect of the matter?
No, my lord.
No judgment.
No judgment on this aspect.
Otherwise, what happens is he has to obtain death certificate first.
Yes.
Then he has to obtain the legal
Legal air
air
certificate.
certificate.
Yes.
Matter goes in appeal,
Yes.
saying that he is not legal air, I am legal air.
Yes.
That will take some time.
Yes.
By all this is over, it will be 3 years.
Yes.
Then he files the application along with this. In such a case, the time taken for obtainment of the
Legal air and death certificate is.
legal air certificate,
Yes.
that should be discounted while computing the period of limitation prescribed for making application for compassionate appointment.
Yes.
This is how I want to.
Yes.
Just I am just thinking that way.
Yes.
Kindly bring necessary material. This is on par with section 14 of the Limitation Act.
The rule also prescribes the power of relaxation of this
The relaxation power is there.
Power to relax is also
Yes,
there.
yes,
Yes, that is there.
Whenever there is a delay in making application,
They can relax.
OCS RA rules,
RA rules.
309 rule contains such a provision which the authority can very well invoke.
No, that is a condoning delay. Again, that will be giving much
By the
discretion to the authority.
By the government.
That is by the government.
That is by the government.
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 But the problem is if the application itself prescribes producing of this document and incomplete, that application will be rejected.
Yes.
Then they will suffer the rejection. Therefore, it should not be left to the discretion.
Yes.
Rule 911.
Rule 911.
That power of condonation.
Power of control.
Give that.
Rule 911. Some rule 11.
No, that applies.
Yes.
Where all compliances are done.
Yes.
Because
Yes.
application has to be complete,
Yes.
but it is filed after delay.
Yes.
There it can do.
Yes, it's.
But I am speaking of the application will not be complete
Complete.
because without legal aid
There is
certificate,
no-
death certificate, it cannot.
There is no such problem.
That I wanted to.
On that aspect also there is no judgment.
Which rule says
Some rule 11 of rule 9.
rule
Regarding condonation.
of rule 9. Notwithstanding the period of limitation prescribed, so it's a day of appointment from the rule may condone government to concerned administrative department by an order to the effect that applicant had sufficient cause for not submitting the application within such period. Brother, you have said that it is time barred. Where is this considered?
That they have to apply. Have to approach.
He has to make application for condonation of delay. It's not a suit. He is already in difficulty because father is dead, husband is dead,
Mother is also dead, my lord.
mother is also dead.
She is alone, my lord. After the marriage of his sister, he is alone, my lord.
Where is the form of application? Name of the applicant, extra
Annexure A.
Annexure A. For details of movable property, if any members so include whether belongs to a CST, the name of the relationship with the DC, particulars of education, it is so the post applied for. No, there is no requirement of legal
Legal certificate, that is the.
There is no
such requirement.
No, that's there. Yes. List of family members as per the legal year certificate issued by the consent. Yes. They have amended. Yes. They have amended, added that also. Brother, I am laying down the law that way. All right. Allowed on the following ground. Number 1. Rule 10 prescribes. Which is the 1 year period? Where is that?
Rule 7, perhaps Rule 7.
Which is the section? Which is the rule?
Rule 7(5).
7(5). No, 7 has no 5 at all.
Amendment rule.
Amendment rules start up to 90 rules, no?
Lordship, it is rejected in the year 2021, man.
Correct. 21. Therefore, 25 rules are not applicable. 1990 rules are applicable.
Not applicable.
2020 rules.
2020 rules.
20 rules. That is
No,
the amended rules.
2020 rules are also there.
Yes, yes. After supersession of this.
Rehabilitation of section 7.
No, that's 7. Sub-rule 5 of the rule.
2020 application submitted after 2 years of death of BC government employee shall not be. Rule 7(5).
Rule 7
prescribes a period of 2 years as limitation.
previously that is 1 year.
Okay. Under the 2020 rules.
No, 1 year is legal.
Yeah?
Rule 7(3).
No.
No, that is amended.
That has been amended.
Yes.
Rule 9(6) of the 90 rules prescribes that period of 1 year.
No, 7(3) also.
2020.
7(3). Mr. Swain is pointing out.
7(3).
Shall be received within 1 year from the date of death of the government.
Of the government service.
5 is application submitted after 2 years.
Yes.
What is the, who makes these rules? Huh? It says 1 year.
Attending
And next it makes 2 years. Then 11 gives power to condone the delay. 2020 rules. Rule 7(3) prescribes 1 year. Rule 7(5) prescribes 2 years.
Rule 9 is not there in 2020 rules.
For condonation.
Yes.
Yes, that is not there.
That is not there.
2020 rules that is not there.
20 rule have to be seen simultaneously to arrive at a conclusion. Because
Yes.
his case comes under 20 rules.
20 rules.
Going by the date of death. So 20 rule has to be made applicable, and their period is only 2 years for making application. There is no power of condonation.
There is no provision for condonation of delay, unlike in the 1990 rules. But however, the application in Form A
That is also a format under the 2020 rules. Format.
specifically requires the Airship certificate. A copy of death certificate and details of each of the family members in the format.
But in his case, 1990 rules will be applicable because the date.
2010 is the dead.
Yes.
2010.
10 is the date.
But there is one judgment of the Apex Court which says,
Court, yes.
as on the date the application is considered, what is the rule should be applied?
Yes.
That will be
Subsequently,
2020 rules only.
Yes. But recently, amending 2020 rules,
Honorable Supreme Court has laid down the law.
That as on the date of death, which is the rule.
At the time of death. At the time of death.
Huh.
At the time, which rule is applicable, that will be governed.
that will govern.
In a matter of Odisha, Honorable Supreme Court has now said that there before the Supreme Court, state has filed an affidavit that we will, wherever we have rejected it, we will allow those candidates to reapply. And their cases will be
by way of
considered as the 90 rules.
Under the
90 rules, not only the 20 rules. Accordingly, they have brought out that amendment. So under that, he
It was incorporated in 2025.
25. That is 2025.
4 September 25.
1997. Rule 1011 provides for condonation of delay. 2020 rules do not provide for that. There is another set of 2025 amendment rules. The application format requires production of death certificate and airship certificate. First. Therefore, while computing the period of limitation, be it 1 year or 2 years, the period taken for necessary certificates, without which application will be incomplete, is liable to be discounted. First off, an argument to the contrary would defeat the very purpose for which the compassionate appointment rules are promulgated. First off, next paragraph. The petitioner's father having died, father or husband? Father having died on 22/12/2010. The rule applicable would be 1990 rules, which provide for condonation of delay. But that aspect has not been addressed in the impugned order. First off, next paragraph. Contention of learned ASC that a separate application ought to have been filed for condonation of delay does not impress the court. First off, it is applications made by a member of the family which is in distress because of its breadwinner's death. First off, it is not a suit for filing application for condonation of, it is not a proceeding before the court wherein application for condonation of delay is filed like under Section 5 of the Limitation Act. First, it sounds illogical and therefore cannot be countenanced. In matters like this, it is ideally desirable to make a short prayer in the very application itself for condonation of delay. First off, however, where no such column is found, still the state being the welfare state has to ascertain the circumstances from the material available on record and then to take the decision as to condonation of delay, whether there is a prayer for that or not. First rule, petition allowed, matter remitted for fresh consideration within 8 weeks.
This is the rule,